Welcome everyone to our workshop, The 5 Steps You Must Take to Plan for the Future of Your Child with Special Needs. We thank you for attending. This workshop is being recorded and all participants will receive a link to the recording within the next few days. My name is Patricia Clay and I'm the Director of Operations and Client Services here at Terabella Law Group. With the overload of people on the internet, sometimes our screens can freeze up and we understand some of the frustrations, but we appreciate your patience should this happen. And if you have any questions during this webinar, please enter them in the question box and John will address them at the end of the webinar. And if you're listening to the recording, he will respond to your questions by email within 24 hours. And finally, John is going to be offering a very special gift to you, so please stay till the end to hear about this gift. So again, thank you for attending, and without any more delays, I'd like to welcome John Hilton.
Thank you, Patricia. My name is John Hilton. I'm a dad, I'm a husband, I'm an estate planning and elder law attorney, and for tonight, I'm your special needs life and legacy attorney. So thank you so much for being here today. I'm honored to spend a little bit of time with you. Now, we're going to jump right in. And if you haven't already, please download your workbook so you can take notes today. The link is in any of your reminder emails leading up to today's webinar. So download the workbook, print it out, and make notes as we go. This is my son, Anthony. He's 30 years old. He has autism and other disabling diagnoses. Now, while I talk about Anthony, I'd like for you to look at the first page of your workbook and complete the section titled My Reality. Now, with Anthony, and this is, I know, true for so many of you who are listening, you know, I did not know what to do for Anthony when he was younger to ensure that he would be taken care of if something happened to his mother and me. Now, this was back before the internet, just to give you a sense of my age. And we couldn't just hop on Google and find resources. And so the only way we had at that time to find resources was to try to go into the yellow pages and make phone calls and make trips to different organizations. And there weren't very many organizations. So I got a lot of advice, and a lot of it was confusing, and I really didn't know what to do with it. For example, you know, should I get insurance to cover Anthony's needs if something happened to me? Should I do a savings account? Some people said, well, you need to set up a trust. You need to create a will, but you need to make sure that you don't give Anthony anything in his will. And all of this advice that I was giving by, you know, family and friends, you know, everyone meant well, but I had no way of knowing how to put it all together and how to create a plan for Anthony. And I'm sure many of you can relate to that. So when I started my journey, this is what my future looked like. I could not see what was around the next corner. There were trip hazards. I didn't know, you know, what would happen next. And all I could do is put one foot in front of the other, take one step at a time, and try to figure it out. But I did. And as a result of that, and having now taken this journey many times, this is what it looks like for me. Now, for you, it probably still looks like that rocky, foggy, curvy path because you haven't been down that path before. But now, having been down that path many times, I feel like it's my purpose and my mission in life to be a guide to other families of children with special needs and to take them down this road that I do know now clearly, and I see the horizon clearly, and help others achieve the protection that I was able to create for my son. Now, I want you to know that your time today is well spent. Now, and I want you to stay tuned. And if you stay tuned to the end, you will receive a link to schedule your complimentary one-on-one meeting with me personally to talk to you about the people you love the most and how you can protect them. I also will have a special gift for anyone who schedules time with me immediately following the workshop. Now, this is important because I take only a very limited number of new clients a month, and I've helped many families with children with special needs plan their estate plan. And while I do have a lot of experience doing this, and one might think that I would just meet with simply anyone who wanted to do this important planning, the reality is that I do limit the number of these appointment slots because I like to take the time to become really well acquainted with my clients and to give them the full amount of time that we need to get their plan exactly right. And I really only want to work with people like yourselves who are taking the time to get educated about these important decisions and who will agree to do a little bit of homework before meeting with me. Now, Dave was a client that came to me with a daughter with special needs. And after we got his plan in place, this is what he said. He said, "We owe you all the thanks for helping to ease one of the many big burdens in life." And I know that Dave, when he came and first met with me, that was what he expressed, is that he was just so worried about making sure that his daughter would be taken care of. And then this is another client, also has a son with autism. And she told us afterwards, "Thanks for all you have done for me. And I can't tell you how secure I feel having all in place for my loved ones." Now, before I go any further, let me introduce you to my family and my reason for doing what I do. And my wife and I, we married later in life, and so we have a blended family. But these are all our kids, hers and mine, but they're all ours. So we have 5 boys, and you can see that some of them have families. One of them is getting married in December, and you can see Anthony there on the bottom left, who is my child with autism. And this is why I do what I do, because what I discovered is that with a proper plan in place, Anthony would be taken care of, as would all of my other kids and my wife. And I knew that everybody in my family, if something happened to me, would have the plan in place to make sure that they were okay, that my wife would be okay, that my kids would receive an inheritance in a way that would not be at risk for them, that Anthony would be taken care of in the way that I wanted him to be taken care of. Now, before we move forward, and before we begin to look at these 5 critical steps that you will need to undertake to really have a solid plan for your child and to plan for your child with special needs the right way, there are 3 foundational principles that we have to keep in mind. And everything that we talk about today is going to be based on these 3 underlying principles. The first one is that you must keep your children out of the hands and homes of strangers. I'm going to say that again. You must keep your children out of the hands and homes of strangers. The second one is you must provide for the care of your child with special needs throughout their lifetime. It used to be that our children with special needs would typically not survive us. But with the advance in medicine and technology, now more than ever, we're seeing adults with special needs outlive their parents. And one of these underlying principles is that we can no longer assume that our children will grow up and go to college, get a job, married, have kids, and we will no longer have financial responsibility for them. Our children with special needs will depend on us, not for the rest of our lives, but for the rest of their lives. And finally, the third principle is that you do have assets that are more valuable than money. And we're going to discuss that a little later on in the workshop. So let's talk now about the 5 critical steps you must take to plan for the future care of your child the right way. And I want you to ask yourself 3 simple questions. Number 1, what would happen to your child with special needs if you did not come home? Number 2, what would happen to your other children? Many of you have 1 or 2 or more children with special needs, but you also have what we call neurotypical children. So what would happen to them? And finally, would your children be provided for financially if you did not come home to them? Hard questions, but we have to face them. So the very first step in planning for your child with special needs is choosing the right guardian for your child. And I hear many people tell me that, well, I already took care of naming guardians for my kids in my will. And I'll look at their will and say, sure enough, yep, it says right there, if I die, I nominate my sister, my brother, whomever, to be the guardian of my child. But normally this is not enough. Let's consider a hypothetical situation. Let's consider that you are fatally injured in a car accident and you leave behind 2 small children. You have a brother who is very successful, has a stay-at-home wife, has 3 children who are excelling in school and sports. And you have a sister who has a good job, is not married, and has no children. Both your brother and your sister petitioned the court for guardianship of your children. Now, based on this above information, who do you think a court would decide is the best candidate to raise your children? The married, successful brother or the single sister? Oh yeah, most of you are probably thinking, of course, the brother. But the reality is we just really don't know. Now, let's add in the fact that your brother's stay-at-home wife is actually a closet alcoholic and abuses prescription drugs. It turns out the only reason his kids are at all successful is because he makes sure they are protected from their mother's addictions. Does that change your answer? Now, how would the court ever know? Now, let's assume, to further this hypothetical situation, that you are not fatally injured in the car accident, but instead you are in a coma. And your will indicates that you prefer your sister to raise your children. Well, here's the problem. Because you are not dead, just in a coma, your will does not even come into consideration. Your will only comes out at your death. But because you haven't died, now who will care for your children while you are incapacitated in a coma? Again, the question becomes, we don't know. So as I move through the following slides, look in your workbook on page 3 and complete the section entitled Guardianship of My Minor Children with Special Needs. So if you do have minor kids at home, I want to tell you 2 quick stories that could illustrate where your kids are at risk, even if you have already named your guardians in a will. Now, if you have not named guardians at all, as 69% of parents haven't, and something happens to you, the choice about who raises your kids will be left to a judge to decide. So several years ago, this is a true story, the Barber family, there are 2 parents and 3 sons. They came to Arizona for a vacation, and they were from California. And while traveling in Arizona, they were in a car accident and both parents died. The boys lived. And when the authorities finally found a family member to pick them up, they found one of the sisters of the mom. So one of the kids' aunts. That sister decided that she should get custody of the kids and their money, but she prevented them from seeing any of the other family members. So after more than $100,000 in court costs and nearly a year of litigation and a huge family fight, a judge decided that a different sister should raise the boys and appointed a financial conservator over the boys' inheritance to the tune of $100 an hour. So those boys' inheritance is being spent on a conservator. And when those boys turn 18, they will get whatever is left. Now, even if you have a will naming guardians, your kids could still be at risk. My colleague realized this when she was out to dinner with her husband one night, and her baby daughter was home with their 16-year-old babysitter. And she realized that she had named guardians in her will, but they all lived across the country, and no one would probably even be able to find her will. At that point, she realized that the authorities would have no choice but to take her daughter out of her home and into the care of strangers until they could, first of all, find her will, locate her named guardians, and then have her guardians make it across the country to her children. And because this was not acceptable to her, she created something that we call the Kids Protection Plan that ensures that no kids are ever at risk from that happening, because it fills in the gaps left by a will-only plan. And when you schedule your life and legacy planning session with me, we will discuss the Kids Protection Plan in greater detail for your children. Kind of to tell you a quick story, I was a paramedic for many years, and I came upon an accident one time, and it was a rollover accident, single vehicle. The mother had obviously died in the accident, the driver, and she had one passenger in the back seat, and it was her 14-year-old daughter. Her 14-year-old daughter was blind, and she had some other developmental disabilities as well. And so she really didn't know what was going on. We couldn't figure out who to call, and her daughter just sat in the back seat, and she kept saying, "Mom, Mom, Mom," waiting for her mom to answer her and let her know that everything was okay, but her mom had died. And we would look through the mom's belongings. We couldn't figure out who to call. So in the end, we only had one choice. And so we had to call Child Protective Services to take this girl into protective custody. I'm absolutely certain that that mother would never have wanted her blind, developmentally disabled child taken into the care of strangers through Child Protective Services. And as a father, the thought of my children being taken into custody by the authorities, cared for by strangers, even temporarily, and especially my son Anthony, who is autistic and really would not be able to absorb and understand what was going on. And while my children are in shock and grief and mourning, being taken into a home of strangers, I just couldn't imagine allowing that to happen. And I know that as parents, you don't want that to happen either. So we're going to talk about a few steps you can take to avoid that scenario for your family here in just a few moments. Now, here's another reason you might want a kids protection plan. If there's anyone in your life you would never want raising your kids, a will does not exclude anyone from guardianship. And if you would never want a specific person raising your kids or challenging your choices, the Kids Protection Plan will help keep those people from ever raising your children. So here's the bottom line. If you do not have a proper and complete legal plan in place to protect your children, a court will decide who will care for your children in the short term while it sorts out who will raise them in the long term. And if you don't have a way to let the court know who you believe should never be allowed to raise your children, the court has no way of knowing. And that person could end up caring for and raising your child. It's really easy to avoid this scenario. And we'll talk about how to do that in just a few moments. Now, there are two types of guardians that we need to consider for your children. We need to name short-term guardians. These are the people who, from the moment something happens to you, are able to get to your children quickly and have legal custody to care for your children, while the courts figure out who will be their long-term guardian. So we have short-term guardians, and then we have long-term guardians. The question becomes, how do you decide who should be the guardian of your minor children? Now, as I go through this, in your workbook on page 4, there is a section titled Select Permanent Guardians for My Minor Children. So go ahead and as we go through this, begin to fill that out with me. Now, on the right-hand side of that table, there is a column that says rank. Do not put anything in that column yet. We'll do that later. So the first thing we're going to do is create a short list. These are people in your life that you believe would do a good job of raising your children the way you would want them to be raised. And we can talk here, these may be your parents, could be your siblings, it could be close friends, aunts, uncles, cousins, maybe godparents to the children, maybe even your nieces and nephews. And it could even be a business partner or a college roommate, someone that how they live their life, and you believe that they would take care of your children. I had a client a couple of years ago who came to me, and we were trying to figure out guardians for her child. And she had an 18-year-old daughter and a 16-year-old son, and her son had special needs. And she was just distraught. She's like, I have nobody in my life. My daughter is going to have to be my son's guardian if something happens to me. And I don't want that for her. I want my daughter to have an independent life and to be able to appreciate and enjoy her brother, but not have to be, saddled for the rest of her life with his responsibility. And I told this woman, I said, I understand as parents of children with special needs, our social circles often tend to shrink down to virtually nothing. It's difficult to take our children out and be social with them like we can with our neurotypical children. But I told her, I said, the one thing that you really need to do, and I encourage you to do this, is to begin to take steps to enlarge your social circle. Bring people into your life that you could at some point in the future say, this person would be a good candidate to raise my child if something ever happened to me. And this woman called me up just a couple of weeks later and said, John, and she was so excited. She said, I went to church, I took your advice, and I went to my church. I haven't been in years. And she said, after the service, she said, this woman came up to me. I didn't even know her. And she told me, she said, I just want to let you know, if anything ever happens to you, I am more than willing and able to take care of your son for you. And I think that was just such a powerful example. And I talk with people all the time who's like, we have nobody in our life. All we have are our kids' siblings. Sometimes our child with special needs is their only child. And many times family has cut them off for whatever reason. And they say, we just have nobody. We don't know how to ever name a guardian. And I give them that same advice. Start now expanding your social circle and bringing people into your life that at some point in the future, you might be able to look at that person and say, maybe this person would at least take care of making sure that my child is safe and fed and clothed and taken care of the way I would want them taken care of. All right, so the first thing we do is we name potential guardians. And I would encourage you to try to think of 3, 4, or 5 people or couples that you believe would do a good job raising your child if you were no longer around. But then the next thing we want to do is we want to fine tune these people that you've named, and we want to make sure that they've actually will raise your child the way you want and raise your child with your values. So the next step is to actually identify your top 3 parenting values. And this can be, there's a list on the screen, and it's not an exhaustive list, but some things that you might think about it might spur your thinking. Would this person, does this person have the potential to love my child with the kind of love that they need? Do they have the children of a similar age that they could raise my child with if something happened to me? Maybe you don't want your child to ever be moved from their school and from their medical care and from their community and the home that they've known all their lives. So maybe that's a value that you have that you're going to put down as one of your top 3 values. But we don't have time to spend a lot of time with this. I wanted to show you this information, which will get you thinking about it. And if you have time right now, go ahead and put down your top 3 parenting values. So the next thing we're going to do is we're going to look at your list of potential guardians. We're going to look at your list of values, and you're going to take each potential guardian and you're going to apply those values to that guardian and say, does this potential guardian meet these top 3 values? And they may meet all 3. They may meet 2 out of the 3. They may meet all 3, but not be real strong in those areas. So now you're going to start arranging your potential guardians and ranking them. And now is when you can go to that right-hand column in your workbook that says rank, and you're going to start writing down who is my first choice, who is my second choice, who is my third choice, my fourth and fifth choice, based on their ability to raise your children with the values that you believe are important, with your priorities. So these are your permanent priority guardians, the ones that you've named. Now, one of the things that I think you should notice is that we are not naming guardians based on their financial ability to care for your child. We're only naming or nominating guardians who will raise your children according to your values and the way that you would want them raised. And that goes back to the second principle that I said in the beginning, that it's your responsibility to make sure that your children are cared for financially for the rest of their lives. And so we're going to talk about how to do that in a moment, but just keep that in mind. These people are the ones who have the values to raise your children. The financial means to raise your children will come from you. So the next step we have is to name short-term guardians. Now, these are the people that when something happens to you and the authorities discover that you have minor children at home, and they know that they have a duty to ensure the safety of those children, that these are people that they can call who will have legal authority to come and take custody of your children while the courts figure out who will be ultimately appointed as a long-term guardian. Now, we call these first responders, and the first criteria that we look at is should be someone that you trust implicitly, and someone who lives within, say, 20 minutes of your child, who can get to your child within 20 minutes. And this is an area where I have a lot of clients say, well, my mother would be my short-term guardian. Oh, great. Does she live within 20 minutes? Well, no, she lives up in North Phoenix. Well, she cannot get to your child within 20 minutes. And the reason that's important is that the authorities are not going to stand around in your home for 2 hours or more waiting for a family member to arrive and take custody of your children. You might get 20 minutes. And if they know someone's on the road and somebody's heading over to take custody of the children who has a legal authority to do so, they'll probably wait 20 minutes for them to get there. But if they don't, then they have no choice but to call in Child Protective Services to take custody of your children to ensure their safety. So this person should also be someone who cares about and can comfort your child, and someone whom your child knows, loves, and trusts. Your child's going to be, if you don't come home, your child's going to be confused. They're going to be traumatized, and this person needs to be someone who they can really find comfort with. The key here, though, is that no matter who you name, other than a very, very close family member, you must provide proper legal documentation that allows your first responder to take custody of your child. Without that documentation, the authorities will not allow your neighbor, your pastor, the child's godfather, they will not allow them to take custody of your child. They must have legal documentation. And we call this, as I said before, our kids protection plan. Now, that takes care of your minor children. Let's talk about your adult children. Because when you have a child with special needs who becomes an adult, many times they will need the protection of a guardian because they don't have the capacity to act as an adult. When I have clients come to me and ask about this, the first question, a couple of the first questions that I ask is, will your child be self-sufficient? Because guardianship is not, necessarily the right choice for all adults with special needs. We have many clients whose children with special needs are semi-independent, who are working jobs and supporting themselves and even have gone to college and graduated. And so, the first question is, what is their level of capacity and level of functioning? Will they be able to be self-sufficient? And will they be able to make personal care decisions? If they go to the doctor needs to do an invasive procedure, do they have the authority? I'm sorry, not the authority, but do they have the capacity to authorize that procedure and understand the risks and benefits? And, so if the answer to these questions are no, or I don't know, or, maybe, we need to sit down and have a serious conversation about guardianship of your adult child with special needs. Oftentimes, like I said before, guardianship isn't necessary, and there are alternatives. And so let's look at some of these alternatives. But before we do, it's important to know that guardianship is a court process, and it's invasive. The court will assign an attorney to your child, your adult child. The court will appoint an investigator to come out to your home and talk to you and look at your home and talk to your child and anybody else that the investigator deems necessary to determine if you are a suitable guardian. And, then ultimately you have to go to court, and the judge has to agree that the guardian, whether it's you or somebody else, will serve and that their choice is in the best interest of your child. So there are some alternatives. One is a limited guardianship. In a limited guardianship, no, let me back up. In a regular guardianship, your child loses all adult privileges and rights. They can't get a driver's license. They can't vote. The guardian has all control over where that adult child lives, who their friends can be. Every decision that a parent could make for a minor child, a guardian can make for an adult child with special needs. But under limited guardianship, we can actually pare back that guardianship role, and we can ask the court, say, there are some areas where this adult child with special needs needs help. They need a guardian, but we want this person to have the full breadth of independence that they are capable of as an adult. And so we can actually pare that down and tailor it to the child's specific needs. We just did this with an adult who has some very specific special needs, but this guy loves to fly airplanes, and he actually already has a pilot's license. So we asked the court, we want him to be able to maintain his pilot's license, and we want him to be able to fly an airplane as long as he is with another adult licensed pilot. And so, there are ways that we can still provide for maximum independence of your adult child while still giving them the protection of a guardian. Sometimes that's not needed. Sometimes all we need is a conservatorship. And a conservatorship is control and authority over the adult child's finances and assets. Some of you are probably already representative payees with the Social Security Administration for your child. Now, two other areas where it's absolutely imperative, if your child has the capacity to do so, it's imperative that your child create and complete advanced healthcare directives. And those are important because we want to make sure that the right people can make medical decisions for your child. If they do not have a guardian to make those medical decisions, then we need to make sure that the right people do have that authority through a healthcare directive. And if your child has the capacity, a durable power of attorney, so that the right people are making financial decisions for your adult child. All right, so we talked about guardianship and making sure that your child is protected. And we talked about, and there is some conservatorship. We talked about if, not naming guardians based on their ability to care for your child financially, but only if they have the values to raise your child in the way that you would want them raised. And we said it's your job to provide the financial resources. So that's the second critical step in caring for and creating a plan for your child with special needs, is you have to provide enough financial resources for your child. Now, while I'm talking about this, go to page 5 of your workbook, and there's a section there titled, which of the following statements describe my current financial resources? And then underneath that is a section called action items. Go ahead and start working on that as I talk. So, as I said before, our children with special needs are very frequently outliving us now. And we do have a responsibility to make sure that they're cared for financially for the rest of their lives. For many of my clients, this is just an overwhelming thought because they just don't have resources. They don't have assets. Some of my clients come in, they got great life insurance policies, they got retirement plans, they've got real estate, and they're not worried about this. But I have others come in who basically are living paycheck to paycheck and have really nothing saved up to care for their child. So, the conversation I had with them is we have to figure out a way to allow you to care for your child when you're no longer here. One of the first steps in doing that is determining how much money your child will need. Working from a standpoint of knowledge is freeing. It liberates us. If we're working from a standpoint of ignorance and we don't know whether we need $10,000 or $10 million, there's no way we can figure out how to put together a financial plan for our child. So in order to do that, we start off with a life care plan. And a life care plan is typically fairly complex. It takes into consideration your child's age, their diagnosis, your income, all kinds of information goes into this. And based on that analysis, we can determine how much money you should be working toward saving or purchasing in life insurance or whatever you need to take care of your child financially when you're no longer around. There's actually, and you just came across this last month, a website called specialneedsmap.com. is provided by New York Life Insurance Company, and it's a life care plan, but it's a shortened version that allows you to spend just a few minutes putting in some basic information to get an idea where to start with your life care plan. Now, my recommendation is that you speak with a life insurance advisor or financial planner who specializes in taking care of families of children with special needs to help you create a more detailed life care plan. But this is a great place to start, specialneedsmap.com. Once you've determined how much money and how many assets your child would need at your death in order to be able to continue being cared for, the next step is to create a special needs financial plan and or purchase life insurance. And for many people, this is this, again, they just kind of like, oh, I don't even know, where to start with this. I have a friend who I met, through my business. He has children with special needs, and he's made it his life's purpose to help families of children with special needs fit into a financial plan and life insurance plan that meets their budget and still provides sufficient resources for your children. And when you meet with me, if that's something that you need, I'm happy to refer you to this gentleman. And he works with absolute passion and compassion for other families of children with special needs. That being said, and most of you, I'm sure, have done this, but don't ever forget those other sources of support. Things like Medicaid, Medicare, SSI, SSDI. Those are all extremely important for your child and may be important for the rest of your child's life. And right now, there are great resources out there to help you apply for and qualify for these resources. All right, so we have to make sure our children have proper guardians named and nominated. We have to make sure that we are providing, by some means, adequate financial resources for the care of our children for the rest of their lives. And then for the third step, we need to ensure that our own estate plan is properly in place. And the reason for this is you want to make sure that if something happens to you, whether it's incapacity or death, you want to make sure that whatever assets you have flow to your children in the right way. So go ahead and turn to page 6 of your workbook and start completing the section titled My Current Estate Plan. And then while I'm talking, there's another section there on page 6 called probate. So go ahead and figure out or complete both of those, My Current Estate Plan and probate, while I talk. So let's talk about your estate plan. There are 3 possible scenarios that you could fit into. One is you have a will. The other scenario is you have a trust. And the third possible scenario is that you have done nothing yet. You don't have a will or a trust. And you are not alone. Some 80% of families have not created a will or a trust. So don't feel bad if you haven't, but listen, because we're going to talk to you about why you need it. Now, let's say you fall into category number 3. You have not done any planning. You do not have a will. You do not have a trust. This does not mean that you do not have a plan, because in reality, the state of Arizona does have a plan for you if you do not plan for yourself. And you may not like it because it's a plan that's designed to cover the greatest number of people possible in what would be most likely a good plan. When you have a child with special needs, the state and the state statutes and the courts do not take into consideration that you have a child with special needs. Your child will receive an inheritance from you just like any other child. If they're under 18, when they turn 18, they will get their share of the inheritance. If they're over 18, they'll get their share of the inheritance outright. And if they have special needs, if they're dependent on any kind of public assistance, then it can really harm them financially to receive an inheritance from you. Now, not everybody necessarily needs a trust. I personally believe that if you have a child with special needs, that a trust is the preferred estate planning tool to make sure that all of your assets go to your children the right way. But, some people may just not feel like that's right for them. However, and we're going to talk about probate in a minute, but if you discover as we're talking about probate, that you need to avoid probate or you want to avoid probate, a trust is one of the best tools that you can use to accomplish that. Now, as a parent of a child with special needs, you might want to consider how important it will be that your child have access to your financial resources immediately, rather than wait for the probate process, which we're going to discuss right now. And also, if you want to protect your child's inheritance from, creditors and lawsuits and divorce and things like that, you need a trust. That's the proper way to do that. So we're going to, we're going to discuss probate, and you should be assured we create will-based plans for many clients, but only after we take a very careful look at all their assets and we get to know the client's wishes, desires, and values will we talk to them about a will-based plan. So let's look at probate. Now, I said before that if you don't have a will or a trust, then the state has a plan for you, and this is it. However, you should know that when we're talking about this process, it also applies even if you have a will. So everything we're about to talk about is true whether you have a will or whether you don't have a will. This same process applies. So let's take a look. If you become incapacitated, then and you're no longer able to manage your affairs, to take care of your children, incapacity for any reason. It could be an accident, a stroke, it could be dementia, whatever leaves you incapacitated. Then somebody has to go to court to get guardianship of you and potentially of your adult child. And this is a court process. And for this purpose, we have two processes. One's called guardianship and one's called conservatorship. And in this process, the court or a judge actually appoints someone to make decisions for you, and or to give your family or give somebody control over your assets, and who can determine where those assets will go and who will get them when, and where you or your family member will live, whether you'll be in an assisted living or a nursing home or at home. That's the power of a guardian, and that's the power the court has when they appoint somebody to do that over you or over your child. So guardianship and conservatorship, a court process. Now, in this same court, this is called the probate court, if you have died, then this court process is called probate. In this situation, your family has to go to court, and the judge will decide where your money goes according to statutes or according to your will. But if you died without a will, then your assets may not go to the people you would choose or in the amounts you would choose, especially if you have a child with special needs and you need to protect their eligibility for public assistance. So again, whether you have a will or don't have a will, this same process applies. So let's take a quick look as we travel through this array on the screen of probate. Now, this is a time-consuming, slow process. In Arizona, easily 9 to 12 months is the fastest this process will take place. Very often, we see them take 18, 24 months. Just depending on the circumstances. It's also expensive. There are attorney's fees, executor's fees, appraiser's fees. You've got creditors coming and taking their share of the estate. You got court filing fees. Your personal representative may have to file a bond to be your personal representative. And it takes a lot of energy and attention by the person that you have nominated or selected to be your personal representative. So the question is, as you know, this probate process, from the time that we file with the court, the time that the court releases your assets to be distributed to your family, a year and a half, 2 years, your kids, your family doesn't have access to your assets. So who would you rather have your assets available to them immediately? your creditors or your children. Okay, so in the probate process, your creditors get paid first. And only after your creditors have been paid, and only after you've assured the court that you've taken care of all your creditors, or your family has taken care of all your creditors, will the court allow you to release the rest, whatever's left over, to your children. Now, if your child has special needs, like I said before, this could disqualify them from benefits. And this is, it's true, especially if your child, if you have life insurance that will go to your child, an IRA or 401k. If you want your child to receive your home, if you have cash in the bank or personal property in your will, if your child is receiving public benefits, and you all know what the state says about how many assets they can have, $2,000 in assets and a very low income, and suddenly they're receiving life insurance or 401k from you, how will it affect their eligibility? And we all know they're going to either lose it or it will be greatly diminished. So let's look at what would go through probate. When you say, well, does everybody go through probate? Well, most everybody would, if you have a will or if you don't have a will. So let's look at what it typically looks like. Now, this is our typical family will come in to see us, and they'll usually have a family home. Often the fair market value is around $200,000. And maybe they have about $125,000 in equity in their home. So they still owe $75,000 on it. And often they'll have, between, bank accounts, savings accounts, maybe they own some stocks, around $15,000 in cash resources. Many times they'll have personal property. And when you think about your personal property, this is all your furniture, TVs, computers, tools, jewelry, china, everything that you own that's laying around your house and in your garage and in your storage unit. This is often valued at around $80,000. That's not atypical. A lot of our parents, because they have a child with special needs, one of the parents will actually stay home and start a business on the side. And so it's not unusual to have an LLC or some other type of business in a family of children with special needs. And we're going to, for this purpose, say that it's worth about $30,000. And many of our families will have bought life insurance. And a $100,000 term policy is very, very common. So when you look at this, there are two columns. There's a column on the right, which we're going to disregard right now, and then there's the column on the left. And if we add that up, we'll see that it comes up to about $250,000. And that's a very common estate, if you will. This is what we call an estate. This is a very common estate of the families that we work with. Now, this estate will have to go through probate. Whether you have a will or not, this estate will go through probate. And the cost of that is going to be at a minimum $3,500, and it could easily go up towards $6,000 or more, depending on how many appraisals have to be done, things like that. And like I said before, this is not going to get through the court process. Your child with special needs will not get access to those assets in that left-hand column for at least 9 to 12 months. But we do have that life insurance policy sitting over there. And if you've named your child with special needs as a beneficiary of that life insurance policy, they're going to get it within a couple of weeks, but they're going to lose their public benefits more than likely. So again, the other thing about probate is that it's public. And what that means is that anybody can find out exactly what's going on with your probate. They can find out how many assets you have, who they're going to. And the reason this is important is because we live in a world right now of very sophisticated scammers. And they know that by finding this information, they can target the vulnerable. And, so that's the last thing we need is your adult child receiving $100,000 in life insurance, and then getting a phone call or a letter from the IRS saying, hey, you just got $100,000. You need to pay us $35,000 in taxes because you got that as a result of your parents dying. Well, if they don't have the ability to counter these very persuasive scammers, they're very likely to turn over some of their money and lose it. So hopefully you've been following along in the workbook. On page 7, you can do this for yourself. There's a section there titled My Assets. So you can take, very quickly just kind of think about, what's the value of your home? How much do you still owe on it? How much cash do you have? And try to put your own values in there. So again, we said this is at a minimum 9 to 12 months, often 18 to 24 months to get this done. And during that time, your children are not receiving your assets from the court. The question is, who will care for your child during this time? Okay. Who will care for your child while they're waiting to receive everything that you've saved up for them? Now, there are several ways, including a will, that your child may receive assets. One of them is an outright gift from a family member. We often have grandparents and other family members who say, I would like to leave money in my will for my grandson or my granddaughter who has special needs. I want to help take care of them after I'm gone. And what do we know about leaving a child with special needs with a cash gift? We know it's going to affect their benefits. And so often not a great idea. The other way is the ABLE savings account and a special needs trust. We're going to talk about that here in just a moment. The first thing we're going to do is look at the ABLE account. And I have a lot of clients ask me about this. It comes from the Achieving a Better Life Experience Act, adopted by the US Congress in 2014, adopted by Arizona in 2016. So it's been around 3 or 4 years. And it's very similar, and it's based on the same IRS code as the 529 college savings account, but it's specifically for children with special needs. And in order to qualify, your child has to be diagnosed before age 26. You can, if you open an ABLE account, the maximum amount that can be contributed to that account from all sources is $15,000. And that's not $15,000 per individual contributing. The account itself can only receive $15,000 in any 1 year. And if it ever exceeds $100,000, then the person that it was set up for can begin losing their benefits. It can be opened by the disabled person, by a guardian, by a financial power of attorney, a parent. But the key thing here is that when the beneficiary dies, whether it's your child or a sibling, whoever that ABLE account has been open for, Medicaid is a creditor to that account, and they can come back in and claw back everything they spent taking care of your child. So it's not a great option for long-term planning. The best use of an ABLE account is if your child has mental capacity to manage some money, they want some independence, they want to be able to go to a movie or go buy a cheeseburger. The ABLE account gives them a special type of debit card that allows them to do that, and it continues to protect those, whatever's in the ABLE account, those assets in the ABLE account are disregarded by Medicaid, Medicare. They don't look at that as an asset. So you can have $25,000, $30,000 in an ABLE account with your child, the beneficiary, and it will not affect their benefits. So it has a lot of great uses, but it does have that Medicaid, what we call a Medicaid clawback provision, that when your child dies, Medicaid is the first creditor on that account. So this question comes up a lot. Well, I've created a will and I've left all my assets to my child in my will. Isn't that okay? So while I talk about this and some of these issues that may arise, go to page 7 of your workbook, and there's a section there titled Planning for My Death, and go ahead and start working through that. So the first reason that creating a will is not necessarily okay is that it's only effective upon your death. What if you become incapacitated? If you have not died yet, your will remain in the drawer. It doesn't come out. So if you're in the hospital, if you're in a nursing home, assisted living, and you don't have mental capacity, then your child's not going to be taken care of. Your will doesn't even come into play. If you leave your child, and I keep saying this, but if you leave your child more than $2,000 in your will, your child will be disqualified from receiving some very important federal and state benefits. Additionally, if you leave, maybe you say, well, it doesn't really matter. I'm leaving my child enough money, they don't need federal benefits or state benefits. Well, that's fine. But at the same time, then whatever you leave your child with special needs is not protected from creditors and scammers, from lawsuits, from divorce and things like that. So it can still be lost without proper planning. And a will in this case does not provide any protection. Some people come to me and they have a will that names a guardian and a conservator. Many do not. Their attorneys did not tell them they needed to do that, or they went online and did their own will and didn't realize that they needed to name a guardian and conservator for their child with special needs. And so upon their death, it would be completely up to the court to try to figure out who would be a proper person to care for your child with special needs. One of the most critical things, and we're going to talk more about this as we go along, is does your will provide instructions for caring for your child with special needs? And I can guarantee you it does not. That's one of the benefits, again, of doing a trust-based plan, is inserting the instructions that you need, that your child needs, that your caregiver and your guardian need to make sure that your child is cared for appropriately. And in the end, on a will-based plan, who's going to take care of your child while you're waiting for the court to decide to release your assets? Remember, we talked about probate. At least 9 to 12 months, more often than not, 18 to 24 months before your child gets anything. Well, sometimes people say, yeah, John, but I've got a plan. I'm going to leave all my assets to my other child. And my other child has agreed that they will take care of my child with special needs for me. And so I have a $100,000 life insurance policy, and I'm going to name my other child as the beneficiary, and they've said they'll take care of my child with special needs for me. That's what good brothers and sisters do. Yes, I agree. That's what good brothers and sisters do. But what happens? What if your child, the recipient of your life insurance, lives in a community property state and gets divorced? They could lose half of that to their future ex-spouse. What if your child who left that life insurance policy with gets into credit trouble and has to file bankruptcy? The bankruptcy court says, why are you filing bankruptcy? You got $100,000 sitting over in that bank account. Oh, no, that's for my brother. No, I promised mom I would take care of him. The bankruptcy court doesn't care. They say, no, that's your money. You need to pay your creditors. Or if your child is sued and has to pay a judgment, the courts don't care what agreement you have with your parents or with your children about who will take care of your child with special needs. They only care about whose name that money is actually in. And so it's a plan that many people try to make work, but it is so risky for much or most of that, or even all of it, to be lost to a divorce, bankruptcy, or a lawsuit. The other thing that happens, and parents don't like to think about this, but we're all human, and I can guarantee you, many of you out there have probably at some point in your life borrowed money from a 401k or from, and said, I'll pay it back. It's the cheapest money I can borrow. 2% interest, pay it out over 5 years. I can never do that at the bank. I'm going to borrow from my 401k. And what happens? 5 years go by, you haven't paid anything back, and now you're paying, all these taxes on it, and good intentions, because that's, because we're human. The same thing can happen. You leave your child, $100,000. They promise to take care of your other child, of their brother or their sister with special needs, and they get in dire financial straits. And they rationalize. They say, I know mom and dad, they wouldn't want me to lose my house or foreclosure. They would want me to use some of this money to make sure that I have a place to live. And oh, by the way, my brother lives with me. So, it only makes sense that I use this money to keep my house out of foreclosure. And so they take from that pot of money set aside to care for your child with special needs with the full intention, I'll pay it back. Things will get better. And just like the 401k, that often doesn't happen. And so these are risky strategies to take on a will-based plan to basically hope that everything works out for your child with special needs. So the only foolproof way to avoid probate and to control how your assets will be used for your children is a fully funded living trust. And I said earlier, so this shouldn't be a surprise to you, that this is what I believe is the preferred way to ensure that all of your assets go to your children in the right way. So how is a trust different from a will? Well, when you create a trust, you get to choose how to distribute those assets to your children, to your heirs. With a will, when they turn 18, bam, they get it. But with a trust, you can actually distribute those according to a schedule that you determine. Many trusts will do this in for example, a series of ages. For example, when the child turns 25, they can receive 1/3 of their inheritance. When they turn 30, they can receive 1/2 of what's left. And then when they turn 35, they can receive the remainder. Or sometimes they'll say, well, they can get 1/2 upon graduation from college. And then if they go to graduate school, then I'll give them the other half upon graduation from graduate school. But the bottom line is that with a trust, you're in control. You get to control when your child receives their inheritance and how much of it, at what age or at what stage in their life. So it's up to you as their parent to determine what's best for your children. Now, a couple of other comparisons. A will absolutely go through probate. A trust bypasses probate. So your children don't have to go through that whole probate process. All the assets pass outside of the court system, outside of probate. We already said a will is time consuming. We're talking about 9 to 12 months minimum. A 1.5 to 2 years is more common. With a trust, those assets are virtually transferred immediately to your children. Now, a will is going to be expensive at the time of probate. Again, we said a minimum $3,500, more likely $5,000, $6,000, maybe more. With a trust, it's virtually no cost at the time of death. A will is public. A trust is absolutely private. Nobody has a right to know what's in your trust. With a will, your children get those assets at 18. With a trust, they get those assets at an age that you determine is right for your children. With a will, all those assets pass to your beneficiaries, to your children, with no protection against divorce, bankruptcy, or judgment. With a trust, you can build in that protection, and you can know that even if they get divorced, those assets, their inheritance, will be safe. So how many of you would like to own assets that can never be touched by creditors, will never be subject to estate taxes, can never be taken away in the event of a divorce? That sounds great, of course. Yeah, hey, I'd like that. Now, what if I said, well, I can give all that to you, but in exchange, you have to give up all control over those assets? You might take a step back and go, oh, I don't know. I'm not quite so interested now. Well, in our living trust, you can actually give your children assets that can never be touched by their creditors, will never be subject to estate tax, can never be taken away in the event of a divorce, and you can give them complete control. So these are cutting edge techniques that only the most knowledgeable estate planning attorneys are taking advantage of. And It's my guess and my bet that most of you would want that for your children and would want to include that in your plan. So what I'd like for you to do is go to your workbook on page 8 and complete the section called My Trust. Now, you may not have a trust, and if you don't, just mark the appropriate box. Now, we said that with a living trust, there have to be other documents, and one of those is a power of attorney. And a power of attorney has to do with giving people authority to manage your financial affairs when you no longer have the ability to do so due to incapacity. And what I'd like for you to do is look on page 8, where it says My Financial Plan for Incapacity, and answer the questions there. And you'll see where do you stand in having an appropriate power of attorney completed. The other associated document would be your advanced healthcare directives. And your advanced healthcare directives deal with who would make medical decisions for you. What decisions do you want them to make for you? And that could be, when you don't have the capacity to make or communicate those decisions to your healthcare team. It could be when you're approaching your final days and death is imminent. How do you want to die? All of that is contained in your advanced healthcare directives. And now would be a really good time to go to page 9 and complete that section that says My Plan for Terminal Illness, Coma, or Vegetative State. Kind of take a close look at what kind of advanced healthcare directives do you have in place, and are they current? And we've already talked about kids protection planning for minors and guardianship for minors and adults. All of this is part of a comprehensive trust-based estate plan, which I believe, again, is the best option for a family of children with special needs. Now, I've already said that the only way you can keep your family out of court, either in the event of death or incapacity, is to have a fully funded living trust. I want to repeat that. A trust can keep your family out of court, even in incapacity and in death. A will-based plan cannot do that and will not do that. So this means that if you've got a trust prepared that is properly custom drafted for your family to say exactly what you want to happen to your assets in the event of your incapacity or death, then all of your assets are owned in the name of your trust, then they will pass according to that plan. Now, if you already have a trust, chances are it's not been updated since you created it. And it's likely out of date because your life changes. Our lives change every year. The law changes and your assets change. So it's important that your trust be kept up to date with the changes in your life and in the law. And based on what my conversations with many clients, it's likely that your assets are not even properly owned in the name of your trust. I sit down with clients in my office and they ask me, hey, John, I've got this trust. Can you take a look at it? I just want to make sure everything's okay. The first question I ask them is not to look at the trust and say, yeah, everything looks great. My first question I ask them is, what assets are currently titled in the name of your trust? And so often the client gets a glazed look on their eye, like, I don't even know what you're talking about. And I'll explain to them that a trust only works when all of your assets have been properly titled to the trustee of the trust. Your home, any other real estate property you have, your vehicles, your bank accounts, your 401ks, all that has to be poured into that trust in order for that trust to work. And I have clients who spent thousands of dollars on a really fancy binder with nice paper that has all this fancy language in it to create a trust, and it doesn't own a single asset. And what this is, when we find this is when they've used either an online service or they've gone to that cheaper lawyer down the road who does estate planning and DUIs and family law and divorces and everything else, because they don't know. And they give them a nice set of documents, but they don't educate the client on how to make it work. Now, remember I asked you earlier how many would like to own assets that can never be touched by creditors, never be subject to estate taxes, and can never be taken away in the event of a divorce? Well, in our living trust, like I said, we can give all that protection to your children and make sure that their children's inheritance when you die is protected against divorce and creditors and lawsuits. And I want to show you on the slide, this is just a sample of a trust that we create. And you can see on the right-hand side that we gave 50% to the neurotypical child in what we call a lifetime asset protection trust. And that trust, that lifetime asset protection trust, holds those assets for that child. Your child has full access to them, but the courts do not. The new ex-spouse does not have access to those assets. And here's the cool thing. When that child dies, any assets left in that trust will pass down to their children with that same level of protection. Now, the other thing we've done is we gave half to the other child who has special needs. And there we gave that child's share to the child in a special needs trust or a supplemental needs trust. And just like the lifetime asset protection trust, those assets are protected. They're protected against divorce, against creditors, against lawsuits. They cannot be touched for taxes. They're there for your child, and they're safe and secure, and Social Security Administration does not consider that a resource. Whether you've got $1,000 in there or $20 million in there, it is not a resource for your child from the perspective of the Social Security Administration. And when your child with special needs dies, if they die with children, those assets can pass down to their children in a lifetime asset protection trust. If they die and do not have children, then whatever's left in that trust does not go to Medicaid. It goes to the other child and it goes into their trust. So either way, your children are receiving all of your assets, and they're receiving them in a way that protects them from taxes and divorce and lawsuits and the courts. So that's just an example of how we will sometimes set that up. All right, so I just mentioned a special needs trust and that diagram. So let's talk about what that looks like. So with a special needs trust, what it allows you to do is to manage your child's resources while maintaining eligibility for government benefits. But there are several different types of special needs trust. There are what we call self-settled special needs trust. And what that means is that, for example, if you had a child who was injured in an automobile accident and has a special needs designation only as a result of that accident, and maybe they receive a judgment, they can't own that cash judgment without losing their benefits. And so it has to go in, if they put it into a trust, then Social Security Administration will disregard it. And so we're using the special needs child's own assets to fund the trust. It's called a self-settled special needs trust. We also have pooled special needs trusts. These are run by nonprofit agencies approved by the state who will service a large number of children or adults with special needs. And because of this large number of pooled assets, they're able to really invest more efficiently and have greater returns on the assets. But they manage your child's share of the special needs trust separately. So they have a professional trustee. If your child needs anything, if your guardian of your child needs to make sure that your child's being taken care of, they can go to the administrator of the special needs trust and say, hey, we need to buy a new wheelchair, or we need to, buy or move my child or my ward to a different home. And the administrator of the pooled special needs trust will manage those assets for your child. Now, notice that on both of those, there's a payback provision. And what that means is that if your child dies and there are still assets left in that trust, Medicaid is still the first creditor, and they can go back in there and they can reclaim assets in that trust, equal to whatever amount they have ever spent taking care of your child. So the third type is what we call a third-party special needs trust. And this is one that's created by you, the parents, or the grandparents, or anybody other than the child with special needs. And you're putting your assets into that, your money, and it can hold anything, any type of property, or houses, or cash, or investments can be placed in this type of special needs trust. Again, Medicare does not look at it as an asset. And when your child ultimately dies, if there is anything left in that trust, Medicaid cannot come claim any of it. It is completely a Medicaid-free trust. So this is the most typical type of trust that we create for our clients. The main thing you have to understand is that you must have the right special needs trust, and it must be properly created and properly drafted. Mistakes in these trusts can cause your child to lose eligibility for benefits. And so you need to use the right kind of attorney who understands what they're doing to get this done right and protect your child's assets and their eligibility. So in essence, a special needs trust done right is a treasure chest for your child. And while I talk here for the next few minutes, go to page 10 in your workbook and complete the section titled Establish a Special Needs Trust. Now, remember just a moment ago, I told you that you could create a trust for your children that can never be touched by creditors, never be subject to estate taxes, can never be taken away in the event of a divorce. A properly drafted special needs trust does all that and more, because not only does it protect your assets, if properly drafted, it maintains public benefits for your child with special needs. So your child can still get all of those benefits that are so often so critical to their care. Medicaid, All-Tex, Medicare, SSI, SSDI, all those benefits your child may qualify for, they'll still qualify. And yet there can be this big treasure chest of assets over there just waiting to be used to help support your child and give them everything that they would not get from federal benefits. All right, so those are the first 4 steps. Guardianship. Make sure that your child has enough money to care for them for the rest of their lives. Create your own estate plan, preferably a trust-based plan, so that you know that all your assets are passing outside of probate immediately to your child with special needs in a way that protects them. And then on top of that special need, on top of that trust, create a special needs trust to hold that inheritance so that your child has the assets available to them at all times without compromising their eligibility for benefits. So up to this point, we've talked a lot about legal documents and we've used a lot of legal terminology. And I want to shift gears for just a minute to talk about what truly happened, or what truly matters, hands down, what truly matters at the end of the day. When it comes to your estate plan, make no mistake, the legal documents matter. You need solid, tailored, custom, personalized legal documents. But ultimately, at the end of the day, while your family will appreciate in that moment that you did an estate plan and you did it right, what they're going to remember you for the rest of their lives is for something much different, not your estate plan. So here we get to the third principle, and that is that you do have assets that are more valuable than money. And so here we're talking about passing on more than just your money. And I'd like for you to look on page 11 of your workbook in a section titled Pass on More Than Just Your Money. And you're not going to be able to complete this section right now, but I'd like for you to start jotting down ideas as I talk in that section so you can come back to it later and complete it. So the question I have for you is, what do your loved ones care about most? And the reality is that they care most about you. They care about your memories. They care about the legacy that you have left them, not about how much money you're leaving them. And I'm talking to a family right now, elderly parents, and the kids are trying to put a plan in place to protect their parents and protect their assets if they have to go into long-term care. And the kids are all telling me, John, we don't care about getting their money. That is their money. We want them to use it. We want it to be used to take care of them. You know, they want to leave us money, but we don't care about that. We just care about our parents being taken care of in their old age. And I think most children feel that way. When you're gone, if you haven't taken the time, made the effort to capture ways in that your loved ones can remember you, they're likely to feel lost without you. And an example for myself, my dad died 20 years ago, and I still don't have any kind of movies, videotapes, audio recordings. You know, I have nothing by which to remember his voice. And I often, 20 years later, I still feel that loss in my life, that I can't just hear my dad's voice one more time. And I know a lot of you are in the same situation with your own parents, but we actually have the option to change that for our children. And, you know, and we can actually give them those memories so that when we're gone, they can bring them back up again. You know, your children, you know, they're not going to put your will on their nightstand to remember you by. What your children, what your loved ones really care about is what you took the time to do to provide them with those memories and to be able to relive those memories. Now, this is a little bit different for your child with special needs, because I believe that the most important gift that you can leave your child with special needs are the instructions for their care. Because no child, we know, no child comes with an instruction manual. And this is even more apparent when you have a child with special needs. And if you want to be absolutely certain that your child's future guardians and caregivers understand your child and can provide your child with the care that you want them to have, you need to create an instruction manual for them. And this instruction manual, it becomes a part of your estate plan. And most importantly, it becomes a part of your child's plan. And when I say you have assets that are more important, you know, than money, I'm talking about making sure that you have all of this planning in place and that manual for your child's guardians so that they know how to take care of your child, and it gives you the peace of mind of knowing that all of your child's idiosyncrasies and all those little things that make your child tick, that your guardians know. My son has autism, and I know that he has behaviors and sensitivities and idiosyncrasies that no one would ever know about unless I told them. And in trying to learn them, my son would be an emotional wreck because there are so many things that he interprets in the world differently than everybody else. So if you have a child with special needs, you know that each child is unique. You know that there's no way to anticipate every need they will have in an estate plan. But the one thing that you can do that's more important than passing on your money is to prepare those written instructions. Prepare that instruction manual for your child's potential future guardians and trustees. So what are we talking about here that's more important than money? Well, along with that, you know, those instructions, we have your human and intellectual and spiritual values. These are things, you know, that we pass on to our children, whether we intend to or not. But if we do it intentionally, then we are leaving them with a purposeful legacy. Your memories, capture those memories, capture them on videotape, capture them on well, I use videotape again, showing my age. Capture them digitally and save them for your children, because they will cherish those. You know, ways that you can show your love when you're no longer there to express it verbally, and instructions for the care of your child. These are the assets that you have that you can pass on to your child that are even more, so much more important to your children than passing on financial assets. Okay, so quick recap. 5 critical steps are, number 1, choose the right guardians for your child, your minor children and your adult children. Provide enough financial resources to care for your child for the rest of their life. Prepare a revocable living trust and all the related documents so that you can be assured that whatever you have will pass to your children in the right way. And for your child with special needs, create a special needs trust to receive that inheritance so that they always maintain eligibility for their public assistance, and they have assets to care for them throughout the rest of their lives. And finally, pass on more than just your money. Pass on your memories, pass on those written instructions, and give your children that gift that's more valuable than money. So go to page 11 on your workbook. There's a section there titled My Truth. And go ahead and complete that. After listening to this webinar, what is your current truth today? And then right below that, make yourself a promise that you will follow up on the information you've learned in this workshop. Promise yourself that you will follow up and you'll take action, and then sign the workbook to indicate that you are committed to doing it. It's a commitment, a promise you're making with yourself. I will never see your workbook. No one else will ever see that workbook. But when you sign your name to that and you say, I am committing to take action, I am going to take care of my child with special needs, I'm going to get a plan in place. It may not be with me. You may find somebody else to work with. That's fine. Just do it. Take care of getting this plan done for your children, for your family. Now, I'd like for you to go back to the very first page of your workbook. Remember why you're here, because in that first page, I asked you to write down the names of the people that need your protection. And now we've talked about the risks and the protections that they need. My children need my protection. They rely on it. My family needs me to do this planning, and they are relying on me to ensure that when I'm gone, that I have made a plan for them, and that they will receive assets the right way, and that they won't have to take my estate through probate. And that's what you need to leave for your family, the ones that you love. And it's the ultimate act of love, I believe, is to make sure that when you're no longer here, you haven't left them in a mess. And you don't have to do this alone. We've gotten through a lot of information, and I believe it's very valuable information. And hopefully you've learned a lot about what needs to be done and what you need to do to put a plan together for your family. Let's talk about how to get that done. You have 3 options, and these are not 3 equal options, I'll tell you right now. Number 1, you can shut down your computer right now and walk away and do absolutely nothing with the information you've learned. That's an option, that's your choice. You can work with an attorney, and you can make sure that you have a tailored, personalized, customized plan. Or you can do it yourself, and you can go online and you can find an online document. And while I've given you a lot of tools today, what you'll find out is, even though it looks simple, it's very complex. And if not done right, will cause more harm and damage to your children than you would do than doing nothing sometimes. So with option 3, work with an attorney. If you sit down with me, I sit down, we talk, I hear your story, I incorporate everything I hear about you, what you want, what you want for your family, what you want in your estate plan, and we design and put together a comprehensive, personalized, customized plan for your family. Now, working with attorneys, many of you may have had this experience working with a traditional attorney. It's not always pleasant. First of all, you get the hourly billing model. You don't really know what it's going to cost at the end of the day to get everything done. A 1-minute phone call or an email, can result in a bill, and it could be a bill for 1/10 of an hour or for a quarter of an hour, depending on how they bill. And so, a 1-minute phone call can end up being billed, to you for 15 minutes at $300, $400 an hour. And so the hourly fees are I believe, part of the traditional model that keep people from seeking the advice and counsel of attorneys. The other thing about the traditional experience working with attorneys is that everything is knee-jerk response. Because you go into the attorney, I have a problem, and the attorney has very limited options. It's okay, well, because you have a problem, we can do A, B, C, or D, or maybe A or B. Whereas, if you planned in advance and if you had everything done beforehand, then you're avoiding the problem in the first place. And so your family isn't having to go through problem solving. Everything's already been done for them. Ultimately, with the traditional attorney experience, you're just a transaction. You're a number. Your matter starts, your matter ends, and then the attorney goes on to the next client, and you don't have ongoing guidance on how to avoid legal problems in the future, how to ensure that your trust is properly funded, how to make sure that your retirement plans and insurance plans have the right beneficiaries named. So in my practice, I flip this experience on its head. Everything I do is flat fee agreed to in advance. So you don't have to worry about every little phone call and every little email, because we don't even keep track of our time. And you can have a million questions about your plan, and I promise you, I have clients who call us every day, sometimes multiple times a day, and we're here to answer your questions and ultimately help you make sure your plan is exactly how you want it. Plus, I love the interaction with clients on the estate planning level because it's so proactive. We're not responding to negative situations. It's all about deciding ahead of time that you want to avoid a reactive scenario later for your family. And I really I enjoy having ongoing relationships with our clients. And I want to stay in touch with you over time, because I know that your estate plan is not a do it once and forget it thing. Your life is going to change. The law is going to change. Your assets are going to change. And your estate plan has to change along with that. And so I like to work with my clients, year after year, to make sure that their plan is constantly up to date and reflective of whatever's going on in their life at their time, because I want to make sure that their estate plan works when their family needs it. So here's our promise to you. When you work with us, your estate plan leaves no stone unturned, and will give you the peace of mind in knowing that your loved ones and assets are kept out of court and out of conflict. That's what all this is about. Keeping your family out of court, out of conflict, passing those assets down outside of the probate process, and doing it in a way that protects them, and without ever having to go through the court process, and without ever facing conflict from family and others. So how do you get started? Well, the first thing you're going to do is we start all planning with a special needs life and legacy planning session. And this is a process that our clients love this process. You will too, because it supports you to get more financially organized than you have ever been before. And it ensures that you make informed, empowered decisions for the people you love, so you know what you actually need to have in place and what you don't need to have in place. And during this process, you're going to actually choose your own fee for the planning you do. By the end of this process, you know with certainty, you know that you're making the best decisions throughout your life, and your family will know how much you cared for them, how much you loved them, how much you cared about them. And in the event of your incapacity of death, everything will have already been handled. Ultimately, this is something you do for the people that you love. And so when we talk about choosing your own plan and choosing your own fee schedule, we have plans that start at around $2,000 all the way up to $8,000. On average, we're usually looking around the $4,000 range. For certain situations, they go even lower than that. The bottom line is, when we sit down and talk, you get educated, you get informed, and then you get to tell me what works for you, what works for your family, and what's best for your family. Once we do the life and legacy planning session, there's actually a total of 3 meetings to get everything in place. So we do the life and legacy planning session. We do all of your plan design at that point. And then you come back about 4 weeks later and we sign everything. And at that time, your plan is absolutely, it's in place. If anything happens to you, that will be the controlling plan. Then we hang on to your plan, we scan it into the system, we do some other work with it, then we bring you back about 4 weeks later for our final meeting. And in that final meeting, we give you all of your documents, we go through your plan funding with you, but we also at that time make available to you the opportunity to capture your legacy through video interviews or audio interviews. We meet with your family and we explain to your family exactly what you've done, what kind of plan you have in place, and how it will affect them, especially if you've named one of your children to be a trustee of your trust, or have some other kind of responsibility. We explain that to them and we let them know, this is the plan that mom and dad have put in place, and this is how it'll affect you. And we give them an opportunity to ask us questions and make sure that they're clear on it. And so ultimately, this is about an 8-week process. In the end, what you've created is a personalized plan to ensure that your loved ones are properly cared for and cared for in a way that you would want. And you're capturing your family wealth, and you're giving them peace of mind, and you're creating peace of mind for yourself, because there's a plan in place, and everybody knows when there's a plan, whatever happens, everybody can go back to the plan and say, okay, what happens next? And everybody knows that it's all been taken care of. So, I really appreciate this time that we've had together. I hope that you've learned something you didn't know. I hope you've taken away something valuable, and I hope you know that what we're trying to create with you is a personalized plan, customized for you and your loved ones, especially your loved ones with special needs, that gives you, the peace of mind that you need when it's all said and done. So thank you for staying with me. I mentioned earlier that there's a bonus for staying on to the end. So congratulations, you stuck it out and we're at the end. And so I want to give you the bonus that I promised you. Now, I typically charge $750 for you to meet with me for 2 hours of education and information designed to empower you to make the best decisions for your family. Your bonus for sticking it out with me today is access to my online scheduler at no charge, so you can schedule your personal special needs life and legacy planning session with me one-on-one to get started on your estate plan. Now, I want to emphasize, I don't just let people get on my schedule without making some promises to me. And, I really prefer anyone who's gone through this training, because you're the ones that get the most value out of that meeting. There is homework to do. There are some things that you have to do in order to qualify further for that meeting. And I want to let you know that if you schedule today, we're going to be here just for another 15 minutes or so. But if you schedule today before we end this webinar, we'll give you an additional $250 towards the cost of a special needs trust. Now, all you have to do is go to terabellalaw.com/schedule-online. You can see it on the screen. Write it down, type it into your computer, into your phone, exactly the way you see it. terabellalaw.com/schedule-online. And when you get there, you'll see the option to schedule a 2-hour meeting with me. And if you do that before the end of this workshop, you'll end up with $1,000 worth of value when you come to see me. In order to get that full value, at the bottom of the scheduling form, there's a place to enter a promo code. I want you to enter the promo code 5 steps at the bottom of the scheduling form. That way we'll know you went through this training with me, and we can make sure that you get that $750 meeting with me at no cost, and that you get that $250 towards a special needs trust. Now recall, I don't take a lot of clients every month. They're limited, and my appointment calendar is limited. And so slots are available on a first come basis. So I encourage you, if you want to get on my calendar, go do it right now while I'm talking. Switch over to another page, go to terabellalaw.com/schedule online and reserve your 2-hour meeting with me, again, at no cost to you. Plus, if you do it before we end this workshop, you're going to get that $250 discount towards a special needs trust plan. Don't forget to put in the code 5 steps at the bottom of your scheduling form. So again, here is the information. terabellalaw.com/schedule-online. Put the promo code in, 5 steps, and then I only have one thing left for you to do. Show up at your appointment, design your plan, and leave with peace of mind. And I do thank you for attending, and I will take some time now. We have time for some questions and answers to the best of my ability. And while I'm doing this, you still have time to check your calendars, see what works for you. Go to my calendar, see what's available, see what works for you, and go ahead and get scheduled for your special needs planning session. And we're going to check out the question box and start answering questions. And anytime during the Q&A session, continue posting questions to the question box. If for any reason I don't get to your question tonight, go ahead and post it, and we will send you an email in response. If you think of something later, or you can't get to the question box, send us an email to Maria@terabellalaw.com, and she'll make sure that we get that email and that we answer your question. Again, you can see that up on the screen. Email is Maria@terabellalaw.com. Scheduling link is at terabellalaw.com/schedule-online. So the booking is open right now. So while we take these questions and work through some answers, go ahead and go there, get your calendar out, and get on the schedule. All right, so Patricia, are there any questions?
Yep, John, there are a few actually. So here's one of, here's a very popular one that we get often is, I don't have a very large estate. Do I still need a trust?
Yeah, that is a really common question. There are people out there who will say that, they come up with these arbitrary numbers. Well, if your estate is worth more than $100,000, you should have a trust. Or if your estate is worth more than $500,000, you should have a trust. I really don't believe that the use of those false arbitrary numbers really have anything to do with whether or not you should have a trust plan or a will plan. What it really boils down to is, do you want your family to avoid probate when you die? Do you want your family to avoid having to go to court for guardianship and conservatorship if you lose capacity. And, like we talked tonight, a will does not prevent that. If you have a will-based plan, your family ends up going through the court process called probate, or they end up going through the court process of guardianship and conservatorship. And, it's expensive, it's time consuming, it's exhausting. If you don't want that for your family, then create a trust and bypass the court process. Make sure that your family gets all of your assets immediately, and they don't have to wait for the probate process to end. You save your family just a lot of pain and heartache by doing a trust-based plan rather than a will plan. Does it matter if you have a lot of assets or a little? It may, but for most people, it's simply a matter of not whether you have 100,000 or 500,000. It's a matter of, do I want my family to avoid probate or not?
So John, this person would like to know if they can still preserve their child's eligibility for benefits if they don't establish a special needs trust.
There are options. You can establish an ABLE account. And I have a lot of clients who come to see me have already established ABLE accounts, and anything in that ABLE account is protected. The ABLE account is not designed to receive your life insurance policies and your home and other assets when you die. So you're able to protect those assets for your child, but it can only hold cash assets. And when your child dies, at some point when your child dies, Medicaid will take everything that they've ever spent in the care of your child. They'll be the first creditor saying, pay us back first. So yes, you can protect your child's eligibility. You can provide some financial flexibility, but it's not a great ultimate planning tool. Other than that, the only way to protect your children's assets and or to protect them and ensure their eligibility for public benefits is through a special needs trust.
Okay, great. So how do I know if my adult child with developmental disabilities needs a guardian?
Yeah, so like I mentioned, a couple of questions that we ask. Will they be able to be self-sustaining, self-supporting? Will they be able to make financial and healthcare decisions? These are the questions that we ask. Every child is so different that really to make that ultimate decision, we have to sit down with the family, and we have to really explore the child's needs, what the family desires for the child, and determine, do they need full guardianship? Maybe they need a partial guardianship. Maybe they don't need guardianship at all. There's really no way to just come out with a simple if this then that kind of equation. It's really a long, detailed conversation with the family to make that determination.
So John, here's a good question. How do I calculate how much money my disabled child is going to need throughout their lifetime?
Yeah, and that's such a difficult question to ask, and sometimes a scary question to answer. Again, the most definitive way is to do a life care plan, and to put all of your information about your child, about their diagnosis, their medical needs, your age, your income, your spending and saving habits, all that goes into a life care plan. And that calculation will show you what you should need to have available for your child when you die in order to ensure that they're cared for the rest of their life. Other than that, a lot of people sit down and try to figure it out, just pen and paper. And what we find is that most people underestimate, because you have to take into account inflation and taxes and changes in the law. And it's just really difficult without a sophisticated tool, and preferably someone to guide you in the process, which is why I suggest you work with a qualified special needs financial planner and a qualified special needs life insurance agent who know how to help you calculate that amount.
John, this gentleman's asking, can I transfer my house into my child's ABLE account?
No. Simple question, simple answer. An ABLE account can only hold cash. If you want to transfer any other asset into any kind of account for your child, it has to go into a special needs trust.
So here's the follow-up. Can I set up my estate to make sure that my child with special needs can live in my house forever, even after I've died?
Absolutely. We do that frequently for our families who have raised their child in the family home. Often the home is paid for or nearly paid for. And, they ask us, like, hey, I really don't want my child with special needs to ever have to move. This is what they know. This is their home. And we can absolutely put that into the trust to ensure that the home cannot be sold as long as the child wants to live there, or as long as their guardian or trustee wants them to live there. And so they have assurance of not just a home, but their home for the rest of their life.
So this person is saying they're going to schedule a meeting tonight before we hang up, but wants to know how much time should they set aside for that meeting, and do we have payment options?
All right, yeah. So our initial special needs life and legacy planning session, you should plan for 2 hours. In that time, we're going to look at your life, your values, your family, what's important to you. We're going to go through all of your assets, and we're going to look at how all of this will impact your family. We're going to look at what would happen if you were to die with your current plan, whether you have a will or no will, or maybe you have a trust. We're going to look at that. We're going to say, okay, under your current plan, this is exactly what will happen if something happens to you. And then if you want to make changes to that, if you don't have a plan and you want to put a plan in place, or if you do have a plan and you want to change it, we'll take the time right then and there to design your new plan. And typically we can get that done in about a 2-hour window. As far as payment plans go, typically we ask for 1/2 of the agreed upon fee up front. And then we like to collect the other half, about a month later when you come back in and sign all your documents. That being said, Patricia's pretty creative in trying to figure out how to make sure that people are able to afford and pay for these plans. So we always encourage you to check with Patricia and see what options are available if that's just not feasible for you.
Yes, I can usually work something out, and it's most important to make sure that we have a plan in place that works for you and your family. So that's our goal. So here is one. If we plan on having more children, should we wait to do our estate plan until after our child's born, or to make sure that they're covered, or should we do it now, or what?
Yeah, I had a very similar conversation with a potential client this morning, and give you the same answer. If you know that you need the plan, there's no reason ever to wait. We don't create these plans that are dependent upon naming your children in the plan. Every one of our plans are set up to name after-born children or after adopted children. So if you have one child and we name that child in your plan, and then a year later you have another child, that newborn child is automatically covered in your plan. So there's no reason to wait. I always encourage, our clients, Don't put it off because you're anticipating a life change. Do it now, and we'll address the life change when it happens. Whether it's a new child or buying a business or whatever it is, because we just don't know what tomorrow holds for us. And I just think it's better to have a plan in place. Know that your family will not have to go through that probate process. Know that they're going to receive their inheritance, your assets, in a protected manner. They're going to get it right away, and in a way that you want them to receive it, especially if you have a child with special needs.
And so, John, I'm going to follow up. There's 2 more questions. There's actually a couple more, but let's wrap it up with these next 2. Can we expedite that process if I'm about to have a baby?
Absolutely. Typically, we try to get this done over an 8-week period. If there's a need, we can move much faster. We can get it done and work around your delivery schedule. It is possible to expedite. It requires a little faster response on the client's part, because we depend on the client to provide us information. And so if the client wants us to expedite, we're happy to, but the client needs to cooperate and expedite the answers back to us as well.
Okay, and then finally, if I have a family member I would never want to be a guardian of my child, how exactly do I protect my child?
Yeah, so as a part of our kids protection plan, we are actually able to write an exclusionary letter that protects your decision. That's not shown to this person that you would want to exclude, but it's available to provide to the court if that person should ever petition for guardianship or should try to challenge your decision making. And so it's a specially formatted letter that we include in your plan that only gets presented to the court if needed. So you can avoid damaging relationships or creating worse relationships by naming this person, by excluding this person because it's kept confidential. But if needed, it goes straight to the judge's hands.
Sorry, I muted my mic and I couldn't get it unmuted. John, I think we should honor everybody's time. It's
I agree.
We've been about 2 hours now. So if for those questions we haven't answered directly here, we'll send you an email and get that email out to you. For those of you who haven't put in any questions yet, but you have some, please email Maria at terrabellaLaw.com, and she'll be sure to answer you right away, or get it to John and he'll answer right away. So.
And if you have been trying to get onto my schedule, and if you've had any difficulty getting onto the schedule, finding it, anything like that, just stop and send Maria at terrabellaLaw.com an email right now and say, hey, I've been trying to get onto John's schedule. I can't get on. I want to get included in that special. I want the $750 planning session at no cost, and I want that $250 discount towards a special needs trust, but I can't get on his schedule. And if you email Maria at Terra Bella Law right now, let us know that you're trying to get on. We will honor that, and we'll make sure that you get on the schedule and that you get those discounts. So other than that, thank you very much, Patricia. And we are going to call it a day. And there's one last look at my son, and hopefully you're thinking about your children right now as well as we say goodbye.
Have a wonderful evening.